quickly run through the next set of 5 MCQ questions. Sixth question states, Mr. Nagarjuna, one of the directors of MGT Mechanics Limited, due to his own business interest, decided to resign as director and accordingly sent his resignation letter dated 12th of June 2021 to the company, stating that he intends to resign with effect from 15th June 2021. Since no communication in relation to his resignation was received from the MGT Mechanics Limited, he sent an email on 17th June 2021 uh, inquiring about the receipt of his resignation letter by the company, but there was no response. However, MGT Mechanics Limited received his resignation letter on 18th June 2021. Out of the on 2021, out of the following four options, choose the one which indicates the correct date for which his resignation will be effective. Now let's see the provision which states the effective date of resignation of director. So here comes the effective date of resignation provision. The resignation of a director shall take effect from the date on which the notice is received by the company, or the date, if any, specified by the director in the notice, whichever is later. So the date on which the notice received by the company is 18th of June, correct? And the date on which the director noted his resignation in the letter is 15th June, whichever is later, henceforth it is 18th of June 2021. We'll quickly move to the next question. HCQ Pharma Limited, a company listed by the Bombay Stock Exchange, was incorporated on 20th January 2002. The directors of the company wants to appoint Mr. Sanjay, who is the managing partner of Sanjay and Associates LLP, a firm of lawyers, as an independent director of a company at the forthcoming AGM to be held on September 24, 2021. Mr. Sanjay is acting as a legal advisor to the Genesis Laboratory Limited, associate company of HCQ Pharma Limited. It is noted advisory. Sanjay charged as part of his advisory solutions that he is provided. Sanjay charged consultation fees as given below. Year 1819, 1920 and 2021, fees in the gross turnover of Sanjay and associates were given in the question. You are required to identify the correct statement from those given below. Now let's look at the provision which states the percentage of the fee from the total gross salary or the gross total income of the consultancy firms in order to appoint him as a managing director. So, who can become an independent director, or in relation to a company, an independent director means a director other than the managing director or a whole-time director or a nominee director who fulfills the following criteria. So here it says in the third point, who has or had a pecuniary relationship other than the remuneration as such director, or having transaction not exceeding 10% of his total income or such income as may be prescribed within the company, its holding subsidiary or associate company, or their promoters or directors during the two immediately preceding financial years or during the current financial year. So it states that if you are having a 10% income of the total income, as such, total income either from the holding subsidiary or an associate company during the immediately two preceding financial years, you are not supposed to be appointed as an independent director. If you have 10% of your total income from the holding subsidiary or associate company, you are not eligible to be appointed as an independent director. See, the statement here is in a negative format, it's in a negation. So when we convert it into a positive statement, it states if the total income or the transactions exceeds 10% of the total income of the company or the person or a firm rendering services to the company, either from its holding subsidiary or associate company in the immediately two preceding financial years, then such person or firm is not allowed to be appointed as an independent director. Now let's go back to the question. So here, if you observe, the gross turnover of Sanjay and Associates and the fee charged in the respective years has been given. So if you clearly observe, the 10% limit has been exceeded in 1819 and 1920. So now we'll move on to the statements. Option A says HCQ Pharma Limited can appoint Mr. Sanjay as an independent director irrespective of the fact that he is a legal advisor to Genesis Laboratory, which is its associate company. Is this statement true? No. Because if there is a relationship with the associate company and the fee charged is more than 10% of his total income, then he is not eligible. So HCQ Pharma Limited cannot appoint Mr. Sanjay. So option A is ruled out. Now, option B. HCQ Pharma Limited cannot appoint Mr. Sanjay as an independent director as he is a managing partner of a firm which is a legal advisor to Genesis Laboratory Limited, its associate company, irrespective of the amount of fee charged by Mr. Sanjay from its associate company. So is that true? No. If the amount charged is less than 10% of the gross total income, of course he can be appointed as an independent director. But here the option says irrespective of the amount. Henceforth, even option B is incorrect. Option C says HCQ Pharma Limited cannot appoint Mr. Sanjay as an independent director as he is a managing partner of a firm which is a legal advisor to Genesis Laboratory Limited, its associate company, and the fee charged by Mr. Sanjay exceeds the percentage specified in the Companies Act 2013 during 1 year out of the 3 immediately preceding financial years. So here, if we look at it, in 2019, 2019 to 20, 10% of the gross total income has been exceeded in the form of fees. Henceforth, 1 out of 3 years he has exceeded the limit prescribed in Companies Act 2013. Henceforth, option C is the correct option. Let's look at option D once. HCQ Pharma Limited can appoint Mr. Sanjay as an independent director even though he is a managing partner of a firm which is a legal advisor to Genesis Laboratory Limited, its associate company, as Mr. Sanjay did not charge any fee during the immediately preceding financial year. So the question says immediately preceding two financial during the sorry, let me take a look at it once. So here it says during the two immediately preceding financial years or during the current year. Even though you haven't charged the fee in the current financial year, your amount has been exceeded in the previous financial year. Henceforth, you cannot be appointed. So option D is also ruled out. The correct option to this question is option C. The next question, 8. The board of directors of MNO Pharma Limited is willing to appoint Mr. R, a qualified cost accountant having 15 years of rich industrial experience, as additional director. But the articles of association are silent about such appointment. Mr. M, the managing director of MNO Pharma Limited, is of the view that board does not have the power to appoint additional director, and therefore, if any such appointment is made, it shall be invalid. From the following four options, choose the one which is applicable in the given scenario. Okay, here it's about the appointment of additional director. Let's look at the provision once. So the provision states, according to this section, the articles of a company may confer on its board of directors the power to appoint any person as an additional director at any time. So here articles is silent, so we can't say that articles is empowering board of directors. Now let's look at the next one. A person who fails to get appointed as a director in a general meeting cannot be appointed as an additional director. Fine. Additional director shall hold office up to the date of the next AGM or the last date on which the AGM should have been held, whichever is later. Okay. With the view to meet the urgent requirements of management, the board of directors is empowered to appoint any person as an additional director at any time if such power is granted by the articles. The notable point is that it is not section 161 subsection 1 but the articles which confer such power. Okay. So here articles of association should empower the board of directors to appoint an additional director. Now let's go back to the question to see what were the options given over there. So option A says an ordinary resolution is in general meeting needs to be passed by the MNO Pharma Limited for appointment of Mr. R as additional director. See, ordinary resolution, special resolution has not been discussed in the provision. It states that the articles of association of a company should empower the board of directors. So option A and option B, which says ordinary resolution, special resolution respectively, is ruled out. Now we'll see option C. An enabling provision in the articles of association is needed which confers requisite power on the board of directors of MNO Pharma Limited for appointment of additional director. So enabling provision in articles of association is needed to appoint additional director. Henceforth option C is the correct option. The last option says the board of directors of MNO Pharma Limited has the power to appoint Mr. R as an additional director, irrespective of whether any clause finds place in the articles of association for such appointment or not. No, the provision clearly states it's the articles which confers the right to appoint the board of additional director to the board of directors. Henceforth, the option C is the correct option. And now we'll move on to the next question. Mr. Z is proposed to be appointed as a director in RLP Mechanics Limited. It is noteworthy that Mr. Z already holds directorship in 1 dormant company, 2 Section 8 companies, 8 public limited companies, and 9 private limited companies. However, out of 9 private limited companies, 2 are subsidiaries of public limited companies. In the given circumstances, is it possible for Mr. Z to accept another directorship in RLP Mechanics Limited without attracting any invalidity? So, now let's look at the total number of public limited companies he is holding. 8 he is already holding. Out of 9, 2 are subsidiaries to public limited companies, right? And 2 Section 8 companies and 1 dormant company. Let's look at the provision on the maximum number of directorships that a person can hold. So the maximum number of directorships is being defined under section 165, which states, according to section 165 subsection 1, a person after the commencement of Companies Act 2013 shall not hold office as director, including any alternate directorship, in more than 20 companies at the same time. Further, out of the above limit of 20 companies, the maximum number of public companies in which a person can be appointed as a director shall not exceed 10. So, maximum number of public companies is 10. Okay. It may be noted that the limit of public companies, that is 10, shall include directorship in private companies that are either holding or subsidiary of a public company. So even a subsidiary to a public company shall be counted as a public company, and the maximum number of public companies should be 10. And then, however, the limit of directorship of 20 companies shall not include the directorship in a dormant company as also in a Section 8 company. Okay, refer exemption note below. It states, exemption states, Section 165 subsection 1 shall not apply to a Section 8 company subject to the condition that such company has not committed any default in filing its financial statements under Section 137 or annual return under Section 92 with the registrar. In other words, a directorship in Section 8 company shall not be counted for determining the maximum permissible limit. Now we'll go back to the question. Here you go. So 8 public limited companies and 2 subsidiaries of public limited companies. So the total count is 10, which equals to the maximum cap. Section 8 companies, dormant companies should not be included. Henceforth, RLP Mechanics Limited, whether he can accept or reject, he can accept the directorship. Okay. Now we'll move on to the options. Option A says it is not possible for Mr. Z to accept another directorship in RLP Limited, RLP Mechanics Limited, since he is already holding directorship in 20 companies. His total count is not meeting 20 companies because we have to exclude 2 Section 8 companies and 1 dormant company. So option A is ruled out. Okay, and then RLP Mechanics Limited. RLP Mechanics Limited is also a public company, right? It says limited. and the maximum public companies that he is already holding is 10. So can he accept the RLP Mechanics Limited offer as a director? No. So you might be thinking, why did I make a contradictory statement? I thought RLP Mechanics Limited is a private company, so I thought there was a private limited. Henceforth I recall my statement, it's an RLP Mechanics Limited, which is a public limited company again. Henceforth, it is not possible for Mr. Z to accept another directorship in RLP Mechanics Limited, since he is already holding directorship in 8 public companies and 2 of such private limited companies, which are subsidiaries of public limited companies. So the maximum cap of public limited companies 10 has already exceeded. So he can't accept an appointment in RLP Mechanics Limited. So option B is the correct option. Option C says it is possible for Mr. Z to accept another appointment in RLP. No, he can't, because the maximum cap of 10 is already done. Option D says it is possible for Mr. Z to accept another appointment in RLP. No, he can't accept. So option A, C, D are ruled out. Option B is the correct option. The next question states, National Software Limited, a government company with 14 directors, is desirous of appointing 2 more directors to enable good governance and to manage its affairs more efficiently and effectively. However, Mr. X, the managing director of National Software Limited, is of the view that the company can validly appoint only 1 more director, and therefore appointment of 2 more directors would be a violation of statutory provisions. Out of the following 4 options, choose the one which is applicable in the given situation. So here the company is a government company. The maximum limit of number of directors of 15 is not applicable to a government company. Let's look at the provision first. Okay, here comes the number of directors in a company. So now let's look at the exemptions part. A government company is exempted from the application of section 149 subsection 1 clause B, which requires a company to have a maximum of 15 directors only. And from the application of first proviso to section 149 subsection 1, which enables a company to appoint more than 15 directors after passing a special resolution. So in case of a government company, and moreover this provision or this exception is only applicable if such government company has not committed any default in filing its financial statements under section 137 or annual return under section 92 with the registrar. Okay, assuming that this the government company in the question has not committed any default in filing annual return or the financial statements, a government company is exempted from both exceeding with the maximum count of 15 directors and passing of a special resolution in case of additional directors more than 15. Henceforth, let's come back to the question. So, National Software Limited is a government company. Henceforth, it is exempted from from having a maximum directors of 15 and passing a special resolution to appoint more than 15 directors. Now, let's look at the options. The contention of Mr. X, the managing director of National Software Limited, that the appointment of 2 more directors in the company, thus raising the number of directors to more than 15, is valid, since such actions shall violate the statutory provisions. Is that so? Is the statement valid? No. Henceforth, option A is incorrect. Option B says appointment of more than 15 directors can be validly made by National Software Limited by passing an ordinary resolution in the general meeting. So passing ordinary resolution, special resolution is not required. It's a government company. It is exempted from the maximum number of directors, and passing a special resolution to appoint additional directors beyond 15. So ordinary resolution, special resolution, these were not the points. Here the view is that it's a government company and it is exempted. So option B and option C, which says ordinary and special resolution, is ruled out now. Now look at the option D. In view of the fact that government companies are exempt from the provisions which limits the maximum number of directors in a company, National Software Limited can appoint 2 more directors, thus raising the total number of directors to 16 from the present 14. Yes, since it is a government company, it is exempted from the provision. Henceforth, it can appoint 2 more directors, raising the total number of directors to 16. Hope these videos are helpful to you. With this, we have completed 10 MCQ questions. I'll upload more videos in the coming days. Please do subscribe to get the latest video notifications, and do share it with your friends to help them understand the MCQ questions. Thank you for watching.